So I make it 12:30, and thank you for joining the Primary Care Direct Employment Issues webinar. This is going to be delivered by Alistair Kernahan and Claire Shaw at Capsticks, followed by Helen Gibson at Agencia Consulting. For anybody who hasn't heard my small brief briefings just now, there is a Q&A and a chat facility. If you hover over the Zoom video at the bottom of the screen, you can ask any questions there. But we're looking to address those at the end because we're going to get through a lot of information. I'll hand over to Alistair now, though, who alongside Claire is going to go through a few of the key employment issues to consider. Thanks, Alistair.
Thanks, Damien. Right, I just wanted to start out, first of all, by outlining a few key employment law issues that are relevant to relationships within PCNs. The development of PCNs today has mainly been achieved by adopting a loose network model of collaboration. So there have been some more formal mergers into super partnerships. And going forward, practices will need to consider, what type of contracting model works best for their PCN to best deliver and manage the growing list of services to patients that they're required to provide. Whatever model is adopted will have an impact on a practice's workforce. New roles and new ways of working across a group of practices covering a wide geographical area will inevitably have legal complications. I'm just going to provide a quick overview of some of the legal issues that this may generate, and then Claire will pick up on some of the more practical HR points. So first of all, looking at the network model, it's less formal and allows practices to work together without forming a new legal entity. It requires a minimal change to existing contracting arrangements with the commissioner and between practices themselves. And in some cases, it can involve one practice taking on the role of the lead provider, who then organises other practices and is responsible for subcontracting delivery of services. Now, under this model, the employment of all practice employees will remain with the individual practices. And this can cause some legal issues when practices need to consider where their employees work and whether they need to work out with other practices within the PCN. To assess the risk, it's essential that the existing contracts of employment for all employees across the network are assessed to determine whether there's sufficient flexibility within those contracts of employment to allow for changes in the ways of working and the necessary movement of staff between practices, or whether there's a need for a contractual variation instead. So what flexibility is there under the existing contract? A mobility clause is an example of a specific flexibility clause which gives the employer the right to alter an employee's place of work. These are commonplace, but employers need to be aware that their use may be restricted by the operation of implied terms, such as a term of mutual trust and confidence. The extent and risk of a practice's power to move an employee under a mobility clause will be a matter of construction and will need to be assessed on a case-by-case basis. In addition, contracts of employment sometimes include express flexibility clauses which give the employer the right to vary terms of employment. However, there are limitations to this. Employers aren't obliged to operate flexibility clauses in a reasonable way, but they need to be careful not to act in a way that will undermine the mutual trust and confidence which is implied into all contracts of employment. Employers also need to be aware that flexibility clauses tend to be construed restrictively by the courts and tribunals, which is why it's important as an employer to assess the risk of relying upon existing flexibilities within the contract on a case-by-case basis. So in circumstances where contracts of employment don't contain the necessary flexibility you require, any change to an employee's role or the place of work will require a variation to their terms and conditions. Now, this can be achieved in a number of ways, but the most straightforward way is by agreement. Ideally, this will involve an express variation of the contract, which is obviously in writing. This gives more certainty to the parties and is easier to evidence in the event of a dispute at a later date. An implied variation, conversely, relies on the conduct of the parties, and obviously there's less certainty involved in that method. If it's not possible to agree on a variation, then as a last resort, you may have to go down the route of dismissing and re-engaging the employee on new terms. This requires the termination of the old contract and an offer of an employment to the employee on new terms and conditions. There'll be no breach of contract in these circumstances, but the termination will be a dismissal, and as such it can give rise to potential claims such as unfair dismissal, even if the employee accepts the job on the new terms being offered. In order to successfully defend such a claim and the risk of such a claim, an employer needs to demonstrate that there were sound and good business reasons for the variation and that it acted reasonably in dismissing the employee. Given the potential risks involved, practices would be well advised to seek legal advice before going down this route. If you get it wrong, then these are the type of claims that can arise in the employment tribunal: breach of contract, constructive dismissal, where an employee resigns in response to an alleged breach of their own contract, and also unfair dismissal. Now, under the network model, all practices remain with the individual practices, as I said earlier. And given the risks of individual practices requiring employees to work across numerous practices, workforce sharing agreements are recommended. The risks these cover aren't just limited to the contractual changes I previously mentioned, but they also relate to issues that might arise when a practice requires its staff to work with other practices within the PCN, for example, allegations of discrimination, complaints of harassment, that kind of thing. So the workforce sharing agreement should set out the obligations and liabilities of all the organisations involved in a PCN and involved in the sharing of staff. To address the risks, the agreement should include, in particular, indemnities, which will cover off possible claims and complaints, which, if they do arise, will often be made against the employing practice alone. So you want to make sure that the risk is shared across all of the practices who are involved in engaging those staff. It can also contain clauses which outline how practices will cooperate with each other in the event that claims and issues arise, so that these disputes can be resolved as quickly and as efficiently as possible. Just looking also at some other potential options for sharing staff. Secondments are a popular method of allowing the employment of an individual to remain with the employment practice whilst they carry out work elsewhere. Usually and preferably this requires some form of written agreement between the employment practice, the host organisation and the employee. Again, this provides all the parties with a degree of certainty as to what's going to happen and how this secondment's going to work and what happens in the event that it doesn't work. Just want to flag up that where long-term secondments are being considered, it's worthwhile seeking advice because on occasion these can be deemed to become GP transfers. So that's just something worth bearing in mind if you are looking at long-term secondments. GP is mentioned as well separately there. This may become an issue, particularly where services are transferred from one practice to another within a PCN. This could amount to a service provision change to which GP would apply, and then you have an issue of whether staff should and will transfer between practices. Again, this is something to bear in mind if that kind of situation arises, and in those circumstances it's recommended that you seek legal advice as to the risk of such a situation arising. And again, this may be something else, and the possibility of a GP transfer is something that may well be covered off and can be covered off in a workforce sharing agreement between all the practices to the PCM. Joint employment is less common and requires employees to sign up to new contracts of employment with all relevant practices to the party. Practicalities to consider if joint employment is an option you're looking at will be to consider who's going to be responsible for paying the employee and how risk and liability will be shared. Just moving on to super partnerships, where two or more organisations merge to form a super practice, that will form a single employing organisation and GP is likely to apply. Where it does apply, the terms and conditions of employment will transfer to the super partnership, together with all rights, powers, duties and liabilities under or in connection with the employment contracts that transfer. Consequently, the super practice could actually inherit potential claims and grievances from the employees that transfer, as well as working practices that might not always be apparent from the contract themselves, but may have become implied through custom and practice. It's worth mentioning that the application of GP is limited to employees who will transfer automatically. GP partners and self-employed contractors, for example, would fall outside the scope of GP. Also, you may also need to consider temporary workers, and there'll need to be an assessment made on a case-by-case basis as to whether those actually would fall or be captured by the TUPE regulations. This is why it's important to deal with due diligence, which helps identify any hidden liabilities that might arise on a TUPE transfer. For example, it will highlight where employees are on long-term sick leave, or other employees with potential or existing tribunal claims that the new employer would want to be aware of before the transfer takes place. The provision of employee liability information under the TUPE regulations is part of that due diligence process and helps employers establish the risks before the transfer takes place. Existing terms and conditions are protected after a transfer, which means that any changes as a result of the transfer will be void. So a super partnership, for example, couldn't simply harmonise terms and conditions after a TUPE transfer without a significant risk. Therefore, it's important to be clear about who transfers and on what terms. Finally, just want to mention the obligation to inform and consult, which is required under the TUPE regulations, which I think Claire will also mention. It's just really to make practices aware that there is this obligation to inform and consult with the representatives of employees who are affected by a TUPE transfer. Failure to comply with the obligations can result in claims in an employment tribunal, which may award up to 13 weeks gross pay for each employee affected by the breach. So given the financial consequences, it's important that practices are aware of the obligations and that they're trying to stick to them. That's it from me from the employment law perspective. So I'll just now hand over to Claire, who will now provide you with some update on some more practical HR issues.
Thanks. Great. Camera just went. Thanks, Alistair. Okay, so just following on from what Alistair described from a legal perspective, I'm just going to talk a little bit about some of those points, but from a practical HR perspective. So if we start with your place of work and mobility, which Alistair's already talked about, and just some of the things to think about in regards to this from a practical perspective. Does your contract actually include for this now? And if not, you might need to consult with your staff in order for them to be able to work across a number of sites. So if your PCN is geographically much more spread out than previously, you may need to think about people not just working at one practice, but working across actually a local area. If you employ new staff, it's worth obviously making sure that you've got that in the contract from day one. Something to think about as well, if you are consulting with staff in regards to something such as a mobility change in their contract, then is it an opportunity to review the terms and conditions in a wider aspect? Actually, you know, do they now actually meet the requirements of the business? Are they in line with the model that you want to move forward? The common agreements, as with contracts of employment, very similar, but you need to have an agreement, and does it reflect the things that you want it to look like? For example, do they cover the indemnity that Alistair's already spoken about? For example, if there was an employment tribunal claim or if there were redundancy costs, if that role wasn't required anymore, you might find yourself in a redundancy situation, and therefore has this secondment agreement adequately covered the indemnity issues that you may face. TUPE, you need to make sure that you're compliant with the legislative requirements that Alistair set out. These are placed on you, such as appropriate consultation. You need to be able to gather the due diligence and the employment liability information within the appropriate timescale, or indeed share it if in fact the employees are transferring out of your organisation. You need to make sure that you fully understand what is the information that's expected from you and what time frame you need to work within. How will that information be shared? Think about the GDPR requirements that you now need to be compliant with, and do you have the safe way in which you can do this? When you get your information, are you in a position and you feel confident that you can actually query the information that you've received? Does it provide you with what you were looking for? And for an example of this is, are you able to challenge if you actually think that a TUPE transfer doesn't apply to an individual with a group of people who are transferring in or out of an organisation? Does their role actually meet the thresholds that you were expecting? Continuous terms and conditions. Staff within the PCN may have differing and varying contracts and terms and conditions. Thinking about the future, this might lead to problems, particularly with relationships. This therefore might present itself as an opportunity to harmonise terms and conditions as well as policies. And this can include anything from your maternity provisions, flexible working, and of course things like pay and annual leave entitlement, as well as absence benefits. It's an opportunity to look at your skill mix. What will you need in the new model? Have you reviewed job descriptions? Are they fit for purpose? Are they best practice? Do they fit with what you need as a business? Are the changes required significant, or will they actually require consultation as well? In terms of appraisal, this is something that I think people forget about, but whose policy will somebody be actually appraised under? How will this physically work in practice, especially when the individual might work across a number of different sites? You know, how will you know if there's an issue if the appraising manager isn't based where the person predominantly works? So just something to think about when it comes to appraisals. And employee relations issues, these will need to be dealt with under that particular employee's policy. But how will that work in practice? Who will actually investigate those concerns if there are any raised? Who will hear conduct or grievance hearings? And how will you implement things like performance or capability processes should they arise? And then the final slide for me is just kind of a couple of hints and tips, I think, really. I think a useful tip is to have a suite of template letters that are in line with your best practice and legal compliance, and they should sit alongside your policies. Examples of these are things like invitations to investigatory or absence meetings and maternity process letters. Think about your current storage arrangements for employee data. Will this be compliant in the new world or your new model? Who and how will they be accessible to, and how will that work? What happens when there's an indemnity issue, such as an employment tribunal claim? Does any of your agreements reflect who will operationalise this? So this is not just a case of cost, which I know Alice has described already, but actually who will carry out the work should there be a claim, in terms of putting all the documentation together, liaising with lawyers, and basically defending that claim and all the correspondence that's linked together. Somebody will need to take responsibility for that. And we're thinking about, you know, overall responsibility in a PCN. And this is not just day-to-day HR matters, but actually your more difficult matters, such as managing absence of disciplinaries. Is it still suitable for the practice manager and those practices to do that? Or should it be somebody who can maintain consistency right across the PCN? So just something to think about in terms of existing roles and kind of moving forward. And thinking of relationships and moving forward, I'll pass over to Helen, who will go through some of those matters with you.
Thanks, Claire. That's great.
Damien, are you able to share the slide?
I will, yeah, definitely, Claire.
Thank you.
Okay, so just to say morning, everybody. Thanks very much to Claire and to Alistair, that's great. And following on from that, just a few things that I'll go through. A little bit of a view from NHS England in terms of what they're looking for in terms of relationships. Then we're going to look at some practical things in terms of what you can actually do to build relationships, particularly across the system. I'm going to go through a couple of top tips, relationships in general, and then we'll finish off with just a short bit on how to manage change, because all of this is obviously connected with managing change and changing relationships. So just a few things to consider. First of all, I want to mention particularly collaboration. We need the right partners, but of course that relationships that may be new relationships, maturing relationships, and certainly at different levels. There's also going to be coordination of care across wider areas. So GPs might be working across multiple sites and as part of MDT teams. That may involve a certain amount of organisational change, and for PCNs to be thinking about the use of MDTs, and particularly how to include new roles and how to embed and support those new roles within the system. There's obviously a need for system-wide leadership and decision-making, and that's a key part of how those relationships are going to work. But also some of those relationships are going to be facilitated by using data, technology, and sometimes some fairly creative and innovative things to be able to make those relationships work well. And I put at the bottom just in terms of relationships, obviously, hopefully most relationships work well. But if you find yourself in a position where you've got a very difficult relationship, do what you can to make the first move and try to find the common ground wherever possible as a good place to start. So what are NHS England looking for in terms of relationships? They're looking to support and encourage better collaboration. And in terms of that collaboration, they're looking for a relationship, particularly between those collaborations. They're looking at population health management. They're going to be encouraging and supporting personalised care and support planning. They're looking for an understanding of the value of existing, new and emerging roles that will be in the makeup of that strong MDT and what that actually looks like. They're also looking for an involvement of local people and communities as partners within this. And they're looking for competencies and skills that will ensure that you've got a strong MDT in place. As part of that, they're also looking for professional and operational responsibility. So who is it that has that? Where does it sit? And of course, the governance and accountability that wraps around that. And the final point is they're looking for a balancing or an effective balancing as much as possible in terms of the voices of those that are both clinical staff, but also the non-clinical staff that will make up that MDT membership. So that's fine, we know what they're looking for, but how can we actually work to try and build those relationships across the health system and make them as good as they possibly can be? And just a couple of practical tips in terms of things that you can do to actually strengthen those relationships. So do what you can to engage with local decision-making structures, whether that's the CCG or whoever that is, engage where you can. Get involved with your local bodies, so the LMC, the BMA regional councils. Make sure that that voice is as strong as it possibly can be at a local level. Focus on the key priorities and the must-dos, because there is a lot to do, and therefore it's really important that that prioritisation and that focus is clear. Do what you can to simplify a complex system. Not always easy, but keep it as simple as you possibly can, and then there's less risk of relationships going wrong. Respect the local priorities and decisions, but have an awareness or be mindful of how that might actually impact at a regional level or beyond. And be clear about the approach and responsibilities and governance, the different work programmes, the roles of NHS England, CCGs, local authorities, etc. Actually, who is it out of those that has the responsibility, and what are the roles of each of those different parties within that relationship system? And ultimately, working together for the benefit of all where we possibly can do. Just a couple of top tips in terms of relationship building, and of course this is focused on PCNs, but they might have wider application for other relationships. Do what you can to develop your own people skills, so think about how you collaborate, how you communicate, and particularly how you might actually deal with conflict in those really difficult situations. Identify your own relationship needs. So what is it that you actually need out of a particular relationship, but also what others might be needing from you and are looking to you in order to gain. Do what you can to schedule time to build those relationships, especially face-to-face relationships if you can. It will pay dividend. Show that you appreciate others, even if you're coming from different perspectives and with different agendas. Be positive, because that's attractive and contagious and will help to oil the wheels of some of those relationships. Be aware of and manage the boundaries that we've got in place and what that actually looks like. I like this one, avoid gossiping, because office politics and gossiping are real relationship killers. So if you can, avoid the gossip. And demonstrate that you're actively listening in order to secure and generate and earn the trust that you might need of partners that you're working with. And just to finish off, this is the final quick slide, which is a bit of a visual, and I find this really useful working not only with PCNs, but anybody that's in a position where they're looking to manage change of some description. And I think this is slightly Blue Peter style, but works pretty well in terms of a simplistic visual. And it shows you across the top all the different building blocks that you need in place, ideally, in order to manage change. You need a vision, you need the skills, you need incentives, you need resources, and you need an action plan. And if any one of those building blocks is missing, or any of those key ingredients is missing, then you're likely to run into difficulties with getting that change to actually be implemented and work in practice. So just a couple of examples down the side, you might find actually if you've not got the resources that you need, there's likely to be frustration amongst people that are trying to implement that change because you've simply not got the resources to do what's needed. Similarly, if you're in a position where perhaps there aren't the incentives to manage that change, whether it's in a relationship scenario or an organisational development scenario, then if the incentives aren't there or you've got the wrong incentives, then there's likely to be resistance to what you're planning. So just a bit of a reminder to keep in your heads as you're working through some of this change, some of which can be pretty complex and long term. Trying to get these ingredients in place will give you the best possible chance of succeeding. Okay, and we're on to the final slide, which is simply the contact details, both for Alistair and Claire from Capsticks, and also for myself from Agencia. So that's all from me, and back to Damien for questions.
Thank you very much, Helen. Thanks, Alistair. Thanks, Claire. That's great. Loads of information there. And yeah, to the attendees who are still with us, which is the majority, if there are any questions, Helen and Claire and Alistair will be hanging around sort of 5-10 minutes. If you do have any questions, now is the time to pose them through the Q&A facility at the bottom, if you remember. Just to confirm as well, as mentioned previously, we'll be sharing this webinar on our website and everybody will receive a link so they know where they can find it, and also we'll be sharing the slides as well. But hopefully everybody found that really useful. If you haven't got any questions, then I will assume that you have. But yeah, we'll be hanging around for 5 minutes. Is there anything else that you would like to add, Helen or Claire or Alistair? Anything that you think might be pertinent?
I think just to reiterate, obviously happy to take any questions or comments either now or afterwards.
Thanks, Helen. Yeah. We'll hang around for 10 minutes and then we'll sort of be logging off around about 25 to or 22. And if there's definitely no movement, then we'll probably log off before then. Helen and Claire and Alistair. I think we've only got 2 more attendees still logged on. Lena and Sylviane, we log off in 2 minutes? Well, or can I assume that you don't have any questions at the moment, or shall we log off in a couple of minutes? If I don't hear from you, I'll assume that's fine. Thanks, Sylviane. Thanks for your response. Okay, no more questions. That's great. Lena, yes, you do have a question. We will be emailing the slides out, and alongside that, you will receive a link to where the video will be hosted on the Primary Care Direct website. Thank you very much.
Thank you.
Yeah. Thanks, Claire. Okay. Thanks, Alistair.
Thanks, Damien.
Okay, I'll speak to you guys a little bit later on.
Okay, take care.
Thank you. Bye.
Bye. Bye, Helen.
Bye. Bye, Damien. Bye, Claire. Bye, Alistair.